My name's Todd Sivia, and I own Sivia Law Firm. We are a firm full of 9 attorneys here to serve you in 4 different locations, including Edwardsville, East Alton, South County, and in our Brentwood location. Our office helps people and their businesses through life's transitions. It's important for you to understand the difference between a will and a trust. And today we'll be talking about the differences between those two. What is a will? A will essentially does 4 things. Gives instructions on how to distribute assets, and properly, upon death, names beneficiaries. So allows you to choose an executor to oversee the distribution of assets. Allows you to choose a guardian to finish raising your minor children. A will goes into effect after you die. It covers any property in your name upon death, but does not cover property held in a trust or joint tenancy. For a will to be carried out, it must first pass through probate. Probate is the legal process in which the court ensures the will is valid, that outstanding debts have been resolved, legal fees and taxes are paid, and that all assets have been appraised before being distributed. So, what is a living trust? A trust is a legal relationship in which a trustee or the person or a person or company holds property for assets of the beneficiary. A living trust allows you to manage your assets both before and after death. Similar to a will, a living trust details your desires regarding your assets, dependents, and heirs. Your assets, such as investments, bank accounts, real estate, and personal property, are all placed into the trust that defines how to distribute these assets upon death. If you are serving as the trustee, it also allows you to name a successor upon your death or upon incapacity. As the trustee, you remain in complete control of your assets and can move them in and out as you wish. There are a few key differences between a will and a living trust. A will does not go into effect until you die, while a living trust takes effect as soon as you create it. This is a key advantage to a living trust in that it allows you to bypass probate. Probate can be lengthy, often taking more than a year to sort out, and it's sometimes a very painstaking process. Furthermore, it can be costly, especially if you have a bigger estate. Probate fees vary from state to state, but generally run between 5 to 10% of the value of your assets. A living trust ensures privacy. Wills are very public. They're very public documents. They're filed in a court. They're open for scrutiny and potential for protests. Probate is also open to public view, which you might want to avoid if you prefer to keep the details of your estate private. However, living trusts are typically more expensive to set up on the front end than most wills because they require a little bit more active management once they're created. It's also important to keep in mind that unless you fund the trust or place the assets into it, it is useless and offers no benefit. Which is preferable will depend upon your situation. The size of your estate is usually the biggest factor. Wealthier individuals can save their beneficiaries more money by choosing a living trust to dodge probate. So, what is defined as wealthy? It depends upon each state. Each state has different rules. In the state of Illinois, anybody that has over $100,000 worth of assets, or they own real estate, you don't have to have it all paid off, but if you own real estate, you have over $100,000. Typically, at that point in time, your assets exceed the limits for what's called a small estate affidavit, which requires, because it exceeds that limit, you're required to go through probate. In Missouri, it's as low as $65,000. So, but it does look at all assets versus just whether or not you have real estate. So it's important to look at each state that you live in or plan to live in the future. So to determine whether or not you need a will versus a trust. So when I explain the difference between wills and trusts, I always use a family example. My great uncle passed away probably 5 to 10 years ago at this juncture, and his estate had real estate. It had some assets in it, and it had 26 nieces and nephews. He had a will, and in his will it specified how assets were to be distributed. It was very clear. There was really no contest between what that meant. The process took 2 years before it was distributed. The attorney took about $5,000. The executor took $5,000, and the process took a long time. Compare that to a living trust, and I use my other family example as another how the process worked. And this doesn't always apply for all circumstances, but my grandfather passed away. And when my grandfather passed away, he had a trust. And at the funeral, my mom asked me the question, what's the next process? What's the next step within the process? Because he had a trust, I told my mother, I said, Mom, go into the bank, change all the assets over into your name, and you're done. If you compare the two, now her circumstances, she was the only daughter, but if we look at the speed in which we can accomplish those goals, is significantly different comparing the two. Now, not all circumstances are the same. You may have children that are under the age of 18. You may have family members that you have different views on distributing it over time, or there are definitely different circumstances. But if we look at that speed with the difference between a will and trust, that's why our office typically looks at more trust. Thank you for joining us. Hopefully we've provided you enough information. If you need more information or if you think that this would benefit you, please contact the phone number below and ask to speak with one of our attorneys.